And if you talk to our principals and administrators, they would tell you this is directly tied to Donald Trump and ICE's tactics. With this law, we're banning ICE from civil arrests and presence in our schools and our child care centers once and for all.
Massachusetts spent the summer building its answer to federal immigration enforcement on at least 3 fronts at once. So that's a new law limiting ICE's reach into schools, hospitals, and courthouses, a wave of temporary protected status terminations that upended tens of thousands of lives, and also at the same time, there's a federal lawsuit trying to kill the state's in-state tuition law that extended it to immigrant students, regardless of their legal status. I'm Jennifer Smith, a reporter at CommonWealth Beacon, and this week on the Codcast, we're looking into how much of this is actually within the state's power of control. So, my guest is Iván Espinoza-Madrigal, Executive Director of Lawyers for Civil Rights, which is the Boston-based legal organization that actually filed one of the earliest ICE courthouse complaints that helped fuel this PROTECT Act, and also brought one of the earliest lawsuits in the country challenging the Haiti TPS rollback. So, Iván, welcome to the Codcast.
Thank you very much, Jennifer. It's a pleasure to be here with you.
So let's zoom out for a second. The PROTECT Act, the TPS terminations, which just actually went into effect yesterday as we're recording this, they finally decided to make official the determination that TPS, temporary protected status for Haitians and Syrians, could actually go into effect, that rollback there. And then the tuition lawsuit are all sort of moving at once. Are you at LCR treating this as one fight, 3 separate ones, kind of a collective problem? How do you look at this?
At Lawyers for Civil Rights, what we are seeing right now is tremendous federal attention to immigration, and in many ways, it's manufacturing a crisis. It's taking programs that have existed for quite some time, have provided opportunities for people to live, work, and study in the United States, be active, productive, contributing members of our communities and our economies, and then turning these programs on their head. Take, for example, temporary protected status TPS. It has long existed. People are vetted before they are eligible to participate in the program to make sure that no one has a criminal background that would disqualify them. And yet the Trump administration came in dead set on making sure that people from Haiti, Central America, and other places that it considers not desirable, start the process of coming off of these programs, which provided employment authorization for many nurses, home health aides here in Massachusetts. And so we're seeing an attack on programs, an attack on immigrants. Take the in-state tuition challenge that the federal government just filed against, and not just Massachusetts, but against many states in the country. These are programs that have been around for a very long time that allow students, irrespective of their immigration status, to be able to afford college by giving them access to in-state tuition rates, something that is extraordinarily valuable. As many people know, the price of college attendance has just skyrocketed over the past few years. And so by just giving people an opportunity to go to school at in-state tuition rates, that's a huge win for immigrant kids who grew up here, who went to high school here, and who can then see themselves, for example, at UMass Boston and be able to go to school, get connected to a job where they can contribute to the economy. These are all wins for all of us in Massachusetts, but the federal government's coming to say, you can't do that. You can't have nurses from Haiti with TPS status. You can't have kids who grew up in Dorchester, went to high school in Dorchester, then see themselves at UMass Boston. And that shouldn't be the case. This is really federal overreach.
So within that context, The state government has been working for quite some time now at this point, prompted by one of the instances in a Massachusetts courthouse that Lawyers for Civil Rights noted specifically. This was agents briefly detaining the 13-year-old of a woman who was at the courthouse. And that was part of what sparked this PROTECT Act, this effort to kind of change where officers engaged in enforcement action could actually conduct those actions. A civil detainer might sound familiar to folks. That's something that's an arrest purely for an immigration status or a detention purely based on immigration status rather than a judicial warrant for a criminal case. So take me back to sort of the first things that Lawyers for Civil Rights was seeing unfold in courthouses, for instance, in Massachusetts on the immigration detention front.
When we think about courthouses, we're really talking about access to justice. We're talking about who has an opportunity to go in and get a protective order. That could be a victim of domestic violence. It's also about witnesses who can come and assist law enforcement in criminal investigations. And so we're talking about victims and witnesses being able to access court proceedings. And for good reason, between both the Democrat and Republican presidential administrations of the past, we have seen strong policies in place that limited ICE enforcement in what's known as sensitive locations. That includes courthouses because of the vital importance of making sure people aren't afraid of showing up to court. If people are afraid to go to court, the entire legal system, the entire justice system can grind to a halt. And so for good reason, the federal government used to deprioritize immigration enforcement in courthouses, just like they did in schools, to make sure that there isn't a disruptive incident while kids are learning in the classroom. And also in hospitals where people are in the emergency room seeking life-saving medical attention. You can't really have immigration enforcement in these spaces that are so sensitive in nature. And yet what we're seeing with the Trump administration is really a rebuke of these practices that used to maintain the sanctity of places like courts, classrooms, emergency rooms and hospitals, and also churches, because churches, these are sanctuaries where people go for prayer and support. And so what we're seeing now is really a rollback of these safe sanctuary spaces and spaces that need to be functional for all of us. We all need to be able to go to court. We all need to be able to go to the hospital. And so when we started seeing a lot of these immigration enforcement activities happening in the courtrooms and around the courthouses, that raises a host of concerns and worries, and also legal challenges because of the nature of how sensitive these proceedings are. And yet courthouses were very slow to tell ICE, don't come in here. Stop doing that. And so it really has taken a significant amount of state intervention, legislative intervention, to make sure that we maintain the safety, dignity of these spaces. And courthouses are at the heart of this, but I also don't want to lose sight of the fact that other sensitive locations, classrooms, emergency rooms, churches, are also included in the legislative efforts that now ban ICE activity in these sensitive locations. What's wild is that we even had to do this as a state because the federal government used to respect these lines. It used to have very clear boundaries. It's the elimination of that respect. It's the erosion of those lines that have led to the state activity. And so, it's important for the state to protect these institutions. And it's sad that it's come to this because the feds should know better than to attack people in courthouses or other sensitive locations.
And so I think that takes us to sort of the messy question in the middle of all of this, which is the state now, as we've noted, has passed legislation essentially saying, well, regardless of whether or not the federal government now has this policy around these safe locations, these sensitive locations, we are now asserting that these are still safe, sensitive locations. There shouldn't be civil immigration action taking place on this property. So the question that's come up a few times is essentially, how secure is the state's legal ground to say federal immigration enforcement can't happen on state property? It can't happen in a school here.
There is very strong precedent for what the state has done by placing what I would call very sensible guardrails around an extremely aggressive immigration enforcement policy. We're talking about a situation where ICE literally is trolling courthouses to snatch people who might be victims of domestic violence or witnesses in key proceedings, disrupting those proceedings to grab people. This is not a hypothetical. This is actually what has happened on the ground. And we're also getting phone calls at Lawyers for Civil Rights from school officials who are concerned that an ICE van is parked just down the street as the kids are out playing recess. And so this is a situation that has been percolating since last year. It happened throughout the fall and throughout the spring. And so if anything, what the state is doing is long overdue in order to make sure that as we go into back to school season, as we continue to have legal proceedings, as people need access to medical care, that all of this is safe and secure space. And this is all well protected under the 10th Amendment, which gives the state broad policing power, broad authority to implement its own priorities. And the federal government needs to respect that and needs to abide by the restrictions and guardrails that the state is imposing. And the state is doing so under its 10th Amendment authority. And this should not be controversial or contested. But as we can imagine, the Trump administration is displeased with efforts to tell federal officials what to do or what not to do. But the reality is that the federal government doesn't have a monopoly on power. And the Constitution creates these important checks and balances, this important system where the rights that are not expressly given to the federal government are reserved for the states. And that's a fundamental basis of our democracy, a fundamental basis of our Constitution. This is the way our country's set up. And so an exercise of state authority in making sure that we keep spaces safe is well within what the state can do. And so we are very happy at Lawyers for Civil Rights to see that the state has finally moved in the direction of protecting these spaces to make sure that witnesses and victims can go to court safely, make sure that people can go to church without fear of an immigration raid, get access to medical care, that kids in the fall will be able to go to school and learn without having the specter of immigration enforcement over their head. That is a threat that no one should have to live with. And our Constitution allows for this type of regulation and guardrail to be set up. And so it's wonderful to see that people will be safer as we move forward.
I guess one thing that obviously came up as lawmakers were discussing this bill initially, and as folks were trying to figure out what can it actually do here, I believe it was Senator Cindy Friedman at the time who noted it's a little bit complicated because even if you say there can't be federal immigration enforcement action on the school property, you can't limit federal action on, say, a public sidewalk outside. You can't, keep there from being people near courthouses, even if not inside of them. So how have you been thinking about the limitations here necessarily, which is they might not be in the sensitive spaces, but they could still kind of be near them? Is it enough of a barrier, essentially, to say that kind of the threshold is where advocates would like to see immigration enforcement not step in versus, are there plans or expectations about what you do if someone is 12 feet away from that sensitive location?
Yes, and this is really where the rubber hits the road, and frankly, it becomes challenging, right? Let me give you an example. Many communities in Boston, around Boston, are very dense urban spaces, and you might have a school building that is just down the street from an ICE staging operation. And does that mean that ICE is targeting the school by setting up their staging area in proximity to the school? Well, if we're talking about a very dense urban neighborhood, that starts becoming more challenging. But at the same time, what's important to remember is that the law protects people not just while they are in that space. Take the school example. Kids, if they're underway to school, or coming from school, all of that is what I would call an academic activity. The minute you leave your house to go to the classroom, the time you spend in the classroom, when you're in the vicinity of that building, because maybe you're playing recess, or you're moving from one school building to the next, or you're in one of the playing fields because you play soccer, or you're on your way back home, or to the bus stop, or from the bus stop to the house, all of those are engagements that are school-based and that deserve and require protection for those kids. And so this is not just a legal protection that applies when you cross the threshold into the school. It has to be something that is much more robust to make sure the kids are safe from the minute they step outside of their house to the minute they return home. And so we need to think about these protections in a very similar way as we think, for example, of the courthouse. It's not just when you step into the courthouse, it's when you're en route to your court proceeding. That victim must be able to get to the courthouse to be able to hold the abuser accountable. So it's not just the minute you step into the courthouse. It's also when you're en route to the courthouse, when you park outside of the courthouse to be able to go into the building. Think about it from that same protection. It's not just the time that you're spending in the building, like the minute the kid walks into the classroom. It's the minute the kid walks out of their home. And the same thing applies to a victim or a witness who's underway to a proceeding, parks their car outside of the courthouse, then steps into the court proceeding. And so we need to think about these from ways that are a lot more robust. And these protections then really attach when these activities start unfolding, not just at the threshold. And so these, I think, are very good questions. But also when we think about the lived experience of that child going to school or that victim heading from home to the courthouse, that's when you start seeing how robust the protection needs to be, because it would defeat the purpose if you are then interceding in the protected right to go to school, to go to court, when you are intercepting people in the parking lot. That defeats the purpose of the protection. And so ICE cannot circumvent the ban by then creating a staging area right outside of the courthouse.
And we'll be right back with Iván after this quick break.
What if you lived next to the largest body of water in Massachusetts, abided by strict development bans in order to protect its purity, but couldn't drink from it? Now what if I told you that whole communities had to move and give up their homes and businesses 100 years ago to make room for the creation of the reservoir known as the Quabbin? I'm Jordan Wolman, senior reporter at CommonWealth Beacon. And that's what communities in rural central Massachusetts near the Quabbin Reservoir have been living through for decades. Except now, a drought that stretched on for 2 years is exacerbating those simmering tensions. These communities, which rely on municipal water sources and private wells, are generally under tighter drought restrictions than those in Greater Boston, which get their water from the Quabbin and are served by the Massachusetts Water Resources Authority. These Quabbin towns are now launching an aggressive push on Beacon Hill to change things up. They want a permanent seat on the MWRA board, a new community trust fund, and increased state aid. a system that they say woefully underpays them for the value of their land that is off limits to being taxed because of bans on development near the watershed. Go to CommonWealthBeacon.org to read the whole story.
What this sort of leads to naturally is the PROTECT Act includes a few different ways to enforce this. The kind of shorthanded way that politicians have been talking about is saying basically that it's clarifying what the procedure is. If, ICE shows up at a school, how are you supposed to handle that? What is your understanding of what this new policy says to someone who maybe works in one of these protected areas? Because one question that's come up to the governor a few times is essentially, well, the law doesn't say call the state police. It says if something happens, you can sue them afterward, or the AG can sue them afterward. Is that accurate?
That is a great question about how enforcement and implementation happens. And I think it's important for not just institutions like a school or a hospital, but even just take a regular workplace where we've seen a few raids in workplaces. Think, for example, of the raid at the car wash in Alston, Brighton, where ICE enforcement happened and a number of people who worked at that car wash were rounded up. And so think about a workplace raid. It's really important to be able to assert your rights in the moment by telling ICE, if it is a private space, that they're not allowed in. And so asserting that from the get-go is a really important element of making sure that you are protecting your rights and creating the record that this raid or this encounter was not consensual. This is an important element of preserving your rights. And so what we are advising people is to assert their rights, to make sure that they know which spaces are public versus which spaces are private. And if you're not allowed, for example, as a patron, in the back room in the kitchen of a restaurant, then ICE isn't either. And so when ICE shows up at that restaurant, ICE might be allowed in the lobby, in the customer area, or even in the dining room, but they're not allowed in the kitchen. They're not allowed in the employee private areas or administrative areas of that business. And so when you think about it that way, when you think about the demarcation of public and private space, that's important when you're talking about where a warrant is needed for entry by any law enforcement official. It could be a police officer, it could be a state trooper, it could be an ICE officer. The same rules generally apply. And so what we encourage people to do is to have a policy in place and a very clear chain of command. And so if ICE is arriving at an establishment or an institution, there should be a very clear response, a very clear chain of command of who greets the ICE officer, who requests the warrant, who explains where ICE is allowed to be and which areas are off limits, and starts creating that assertion of rights that is going to be very beneficial to make sure that ICE is not stepping out of bounds. And so the same thing applies in a school, where really in a school, officials should have one person who interfaces with ICE, who is trained to review a warrant, who then can call an attorney who explains where ICE can be or not be. And if we're talking about certain places like a courthouse or a school, the answer to that is probably zero, like no space where ICE can be. And so it's important to make sure you understand your rights, how they apply in that particular space, whether it's public, private, or a school or a courthouse, and then be able to assert that in real time. Because if you don't assert that in real time, then the remedies in many cases will have to be after the encounter, which obviously can be challenging because some of the harm or injuries may have already taken place. And so it's harder to make people whole after the fact. So I think enforcement should be thought of as something that happens as soon as you see the ICE officer, instead of thinking about a remedy afterwards. And so let's put the emphasis on what the interaction is like, how to manage and navigate those interactions safely within the confines of the law, and make sure that if they need a warrant, that you're asking for a warrant. And if they're not able to be in that space, that you let them know that they're not allowed to be in that space and that encounter is not consensual.
And one of the things that has come up, of course, from critics of this new law and from the folks who wanted to roll back those secure space protections in the first place is essentially that this is going to impede the operations of immigration enforcement in identifying and detaining dangerous people. The governor, Maura Healey, has repeatedly said, she was a prosecutor. She understands kind of the relevance and the importance of detaining dangerous criminals. Obviously, from an advocacy perspective, you're not looking at this in terms of just how do you round up as many people as possible, but how are you dealing with or kind of processing the critique of this as it making it harder to find people who are an active threat to those in their vicinity?
I think it's important to remember that the public safety argument is on the side of regulation and guardrails for public safety purposes, to make sure that victims and witnesses can access a courthouse, to make sure that kids can go to school, to make sure that anybody who needs emergency medical attention can go to a hospital, to make sure that we can convene on a Sunday for Mass. These are all critical things. And it's actually the federal government that's creating the public safety harm and the public safety jeopardy by diluting the very, very strong boundaries that have historically existed between these spaces and law enforcement. And it's the erosion of these boundaries that has created these dangerous situations for law enforcement officials. And so if the government under Trump were respecting the same rules and boundaries that have existed historically in both Democrat and Republican administrations across time, we would not be in this very dangerous situation where victims of domestic violence forego protective orders because ICE is trolling courthouses. No one should have to live with that type of uncertainty. No one should have to fear the consequences of physical violence versus deportation. That is a terrible place to put victims. That is a terrible place to put witnesses. That's a terrible place to put anybody who has business with a court. And so when we think about it from a perspective of public safety, it's actually in public safety's role and purpose that the rules are in place. And it's the erosion of federal guardrails that has led to this situation. And so when I look at what the current landscape is, it's actually bringing order to chaos to have the rules, guidelines, and guardrails that the state is now imposing. This is critical because, as we've seen over the past year, ICE encounters have even resulted in fatalities, which is an incredible situation to have, where civil immigration enforcement is resulting in people being killed on the streets of Maine, Minneapolis, Texas. And so when we think about public safety, the side of public safety is law and order. Law and order here is allowing victims and witnesses to show up to court. It's not allowing unhinged, unregulated, untrained, rogue immigration activity to continue on the streets unrestrained without any federal response to the violence. And so when we talk about public safety, it is the state's prerogative to impose these regulations to make sure that all of us remain safe from ICE violence. And it's also critical to remember that the guidelines for secure and sensitive locations was in place for decades until Trump eliminated those safety protocols. So it's really shameful for the government to say that it has to resort to attacking people in vulnerable places to be able to do its job. Law enforcement has always been able to do its job using traditional law enforcement tactics. We know that ICE enforcement has always happened in our communities. What we are against is the unconstitutional enforcement of ICE arrests. It's knocking down a door without a warrant. It is hauling a victim out of a courtroom who's trying to seek a protective order. None of that is in the service of public safety. None of that is needed for traditional law enforcement practices. And if that's the best argument that the Trump administration can make, then it's shameful that it needs to resort to rounding up victims of domestic violence to meet its quotas.
Are you expecting there to be a suit from the Trump administration against the Massachusetts law and other states that are looking at kind of these similar sorts of state codification of what had been federal policy here around secure locations? They're already suing Massachusetts over the in-state tuition law, saying that effectively it's discriminating against American citizens, students in other states who have, legal immigration status but are not entitled to in-state tuition policies. Is the PROTECT Act next, essentially?
The Trump administration has showed not just a blatant disregard for tradition and for practices that have long kept all of us safe, like the respect around sensitive locations, but it has also been really inverting notions of victimhood. Who deserves protection from the Department of Justice? Who deserves protection from the EEOC or other federal agencies? And so this inversion of victimhood is part and parcel with an effort to demonize immigrants, part and parcel of an effort to dilute DEI and other initiatives and programs. And so it would be no surprise to me that the Trump administration may file a bogus lawsuit against Massachusetts to try to challenge the latest immigration protections that the state has put into place. But it's important to remember that time and time again, case after case, especially with the cases that Lawyers for Civil Rights has filed, that the Trump administration has been on the losing side. This is not something that the courts are going to allow, just like we saw the courts rebuke the Trump administration's efforts around birthright citizenship. And so we are fully confident that when push comes to shove, if the Trump administration attacks Massachusetts yet again for another lawful exercise of state power, that the federal courts will continue to put the Trump administration in its place.
And this brings us, I think, to the last thing here, which is speaking of courts. We are right now, as we speak, trying to see what the next approach is from the Trump administration to the loss of TPS status for Haitians and Syrians. Again, that's about 45,000 Haitians who are on TPS or had TPS status in Massachusetts right now. That's suddenly a lot more people who are suddenly considered not necessarily legal residents in this country. What do you expect the knock-on effect to be in Massachusetts if there's both an attempt to ramp up deportation proceedings and you also now have this 45,000 people who are no longer considered appropriate to have in the state under this status?
It is deeply unfortunate that the Trump administration has manufactured this crisis. There were thousands and thousands of people who were living and working lawfully with temporary protected status, TPS. And in Massachusetts, we particularly have a dog in this fight because we have many people with TPS who are a part of our communities. Think, for example, of the Haitian community, which is one of the largest in the country after Brooklyn and Miami. Boston is an epicenter for the Haitian diaspora. And so we see that impact in many of our institutions and in our economy, where Haitian nurses and home health aides are very popular and ubiquitous in our healthcare system. And yet many of these nurses, nurse practitioners, home health aides also have TPS. And so what we're seeing is that nursing homes are missing talented staff that it has trained and developed as part of its workforce and pipeline for many, many years. And so this is going to make having access to medical services, especially for aging baby boomer populations, even more difficult. I know people already complain about long waits to see a doctor. Well, the wait's going to get longer. People already complain about the fact that we don't have enough people to do things like home visits and home health aid work. And yet that's going to become even more challenging now. And so this is going to have a real impact in our economy. And the baby boomers are going to see it the most because they're the ones interfacing with much of the labor force that is now suddenly undocumented, all because Trump decided that he did not like the temporary protected status program, and that he didn't want people from countries like Haiti to be in the United States. And so this is a manufactured crisis. Why we need to remove Haitian nurses out of the country and put them on the same immigration deportation priority as hardened criminals is beyond me. And so what we are going to see is a dramatic impact in the Massachusetts economy in the coming months as these people start being laid off or start being separated from employment. And we're also going to see a lot of activity happening because immigration may be prioritizing people they perceive to be TPS recipients as part of their enforcement activities. So you can imagine a Black person walking in Mattapan, which has a large Haitian population, suddenly being racially profiled by ICE just because they're Black and walking in a neighborhood that happens to have a disproportionate TPS constituency. And so we're getting ready for these incidents at Lawyers for Civil Rights. We're gearing up to be able to hold ICE accountable for racial profiling in neighborhoods like East Boston and Mattapan, in the same way that Lawyers for Civil Rights has been holding ICE accountable after the raid in the car wash in Allston Brighton and after so many other rogue immigration activities. And so we're committed to defending the rights of our communities and to making sure that we implement and enforce all the tools at our disposal to keep all of us safe.
Okay, well, all of this is going to, of course, as you know, continue unfolding rapidly over the long term, both at the same time. We're going to see if there ends up being any kind of legal conflict over the new PROTECT Act rules. But for now, thank you again, Iván, so much for joining me.
Thank you, Jennifer. It's a pleasure to be here.
And of course, to everyone else, thank you so much for listening. I'm Jennifer. Our production and theme music is by Charlie Koczela. Email codcast@commonwealthbeacon.org, and we will be back next week.